Thank you for joining us for this evening's program with Professors Keith Whittington and Stephen Vladak and attorney Ron Robbins moderating. I'm Claire Noble, the Director of Programming for the Vail Symposium. On behalf of Chris Sable, our Executive Director, Dale Mosier, our Board Chairman, and the entire Vail Symposium Board, welcome. We are now in our 49th year of providing the Vail community with thought-provoking, diverse, and affordable programming. A few program notes before we get started. At the bottom of your screen, you'll see an option for Q&A. That's where you'll type your questions for tonight's speakers. We'll get to those questions later in the program. We'll get to as many as time permits. Please keep those questions on topic and as concise as possible. Tonight's program will run until 7 p.m. It's being recorded, and you'll be able to find that recording at vailsymposium.org. I'd like to take just a moment to thank the organizations and individuals who've helped make tonight's program possible. Our sponsors include the Town of Vail, Vail Resorts Epic Promise, the Antlers at Vail, and the Vail Daily. Our virtual programs are sponsored by Alpine Bank. Cindy Ingalls and Leela and Walt Misher have underwritten the summer season. Kathy and Neil Kimmel have underwritten the Hot Topics series. And tonight's program was underwritten by Ann and Tom Rader. The Vail Symposium is also supported by a generous grant from the Frechette Family Foundation. Thank you to all of our donors. We couldn't do it without you. This is the first program of our summer season, and we have more than 20 programs scheduled between now and November, with topics ranging from voting and elections with Colorado Secretary of State Jenna Griswold to Colorado taking on big tech with Colorado Attorney General Phil Weiser, to the state of media with veteran journalist Judy Woodruff. Our next program on Thursday, June 3rd, examines rare earth elements, what they are, where they're extracted, and why they're cause for concern in both our supply chains and with national security. That's Thursday, June 3rd. Now we turn our attention to the Constitution. Our distinguished guests are Keith E. Whittington, the William Nelson Cromwell Professor of Politics in the Department of Politics at Princeton University. He has published widely on American constitutional theory, American political and constitutional history, the law and politics of impeachment, judicial politics, the presidency, and free speech. Stephen I. Vladak holds the Charles Allen Wright Chair in Federal Courts at the University of Texas School of Law and is a nationally recognized expert on the federal courts, constitutional law, national security law, and military justice. Vladak has argued before the U.S. Supreme Court, the Texas Supreme Court, and lower federal civilian and military courts. Ron K. Robbins is a member of Kaplan and Ernest's Family Law Section. Based in Eagle County, he has significant experience in family and domestic law, as well as managing civil litigation, business transactions, real estate, and real estate development matters. He frequently appears on local and national media as an expert on legal issues, including on Fox, CNN, CBS, and MSNBC. He has also authored a weekly legal column for the past 25 years at the Vail Daily. I'm going to hand the program over to Ron Robbins, and I'll be back later in the program with audience questions. Again, please place your questions in the Q&A. Ron?
Thank you, Claire. It's good to be back with the symposium and honored to help kick off this first program of the summer. Let me say one thing real quickly before we actually begin the Q&A. This being Vail and Vail being renowned for its informality, I did speak with Professors Whittington and Vladak before we began the program and asked their permission, in intending no disrespect, to refer to each of them by their first names, and they graciously consented. So we'll get them to be Vailites. With that, let me start with the first question, which is about the Electoral College. And I think, as everyone knows, in the tumultuous 2020 election, the Electoral College became an issue of substantial weight and gravity and a little bit of hand-wringing as well. The question being posed to both of these professors is Article 2, Section 1, and Clauses 2 and 3 speak to the Electoral College without actually calling it the Electoral College. I'd like to hear from each of you what the basis of the Electoral College is, the powers of the Electoral College, the relevance, and the possibility of repeal.
So that's a lot to cover in a very short amount of time. So it's a big question. So the Electoral College has, of course, evolved dramatically across American history. We've modified significantly how it actually works. It doesn't really work in the fashion that the founders imagined. They were struggling to figure out how exactly do you elect a president given no real experience with how to run the kind of election it would take to nationally elect a president under the circumstances in which they're operating. And they thought the Electoral College would, one, mirror the kind of representative structure they'd already carefully negotiated for Congress, and two, help facilitate the kind of information flows that would be necessary to choose a presidential candidate across a nation which people didn't really know who the available candidates were likely to be once you're past the obvious possibilities like George Washington. Obviously, that's not our situation today, and yet we're still working with this basic system. They imagined at least the possibility that electors would actually exercise discretion in casting ballots in choosing presidents. We almost immediately abandoned that idea, and we have over 200 years of practice in which we expect the electors to simply do what it was the voters told them to do. So we expect them to be a mere pass-through for the voters' own choice of presidents. And if they didn't behave that way, the Electoral College would be far more intolerable than we imagine it might be otherwise.
So can I just, Ron, I'll jump in because Keith is right. This is such a massive subject. I want to start with your last question, which I think is the easiest to answer, which is it can't be fixed, at least not in the sense of being wiped off the books. And the reason for that is because, as Keith has written about beautifully and knows as well as anyone, it is incredibly difficult to amend the Constitution, but especially in a context in which you're amending the Constitution to weaken and dilute the power of smaller states, because the Constitution's amendment process requires 2/3 of both houses and 3/4 of the states. And so even if there is broad national popular support for abolishing the Electoral College, the notion that you're going to get 38 states, that no more than the 12 smallest states would oppose this, I think is a long shot. I want to just run one thing though, which is that the Electoral College has evolved in ways we didn't expect alongside the party system, which has evolved in ways we didn't expect. Does not mean we are stuck with it in its current form. And I think the sort of the one important point I make here is the relative power of small states in the Electoral College is heavily influenced by the size of the House of Representatives, right? Where, Wyoming has 2 senators and 1 member of the House versus California's 2 senators and 53 members of the House. The House has not expanded permanently anyway since 1911, at a time when the population of our country is about 1/4 of what it is today. And so, I think for those who think the Electoral College gives too much power to small states, I agree. But I think one of the ways you fix that is actually by diluting the Senate's role in the Electoral College. And also, I think, with the salutary effect of increasing the representativeness of the House to mirror at least what was true for most of American history from 1789 to 1911. Indeed, really quickly, the very, very first amendment that Congress adopted in what became the Bill of Rights was not what we think of today as the First Amendment. It was an amendment that would have required the House to grow in proportion to the country over time, not necessarily because of this problem, right, but to ensure representativeness. So, Ron, I think the Electoral College is a problem, but I also think it is a problem. It's a symptom of a broader disease, where much of what we think of as the particular curse of the Electoral College could be, at least to a large degree, mitigated if we, revisited the size of the House and various other things along those lines. So, the short version is, can't get rid of it, can probably make it less of a sort of sore sticking point in our quadrennial presidential election process.
Let me ask a very quick follow-up, or 2 very quick follow-ups to this, and we'll move on to the next question. Does any other nation have an electoral college or the equivalent of an electoral college? And will both of you speak just very briefly as to the concept of a faithless elector?
Yeah, nobody has it in anything like its current form. There are some Latin American countries the replicated versions of the Electoral College when they were drafting their constitutions, and they very quickly abandoned it. It's not being a good idea. And so the United States is unique in having this kind of system and sticking with it over time. It's not the kind of feature of our Constitution that anyone really wants to replicate. And the idea of the faithless elector is simply a presidential elector who breaks their oath and refuses to cast a ballot for the candidate they were originally selected to cast their ballot for. And so a Democratic presidential elector who refuses to cast a ballot for the Democratic nominee in that particular case. And there are examples all through American history in which individual electors have broken that pledge in that way, although fortunately never in the kind of numbers that it would actually affect the outcome of a presidential election.
And I'll just say really quickly, Ron, there was a Supreme Court case from last year, actually, where the court basically held that states that want to make it unlawful to have faithless electors are allowed to do so. So, Colorado, I believe, is one of them, right, where it's not that faithless electors are per se unlawful, but states can prohibit them if they want to. And I think we will probably see more efforts for states to do so, in the years to come.
Let's move on to separation of powers. The first article of the Constitution provides that all legislative power shall be vested in the Congress. The second article vests power in the executive. The third article vests power in the judiciary. Would you talk about separation of powers, the creep of increasing presidential power, and particularly in the context of Marbury versus Madison and the role of Chief Justice John Marshall?
So there's a lot there. I mean, the separation of powers as the founders envisioned them are sketched out with a lot more detail in talking about Congress than in talking about the powers of either the court or the executive branch. And so we've seen a lot of development over time about how exactly the branches relate to one another, what exactly the powers are that they exercise in relation to your point about Marbury versus Madison and Chief Justice John Marshall. The Constitution doesn't specify that the court has a power of judicial review. It's understood to be implicit in the constitutional design. And so John Marshall articulates the logic of it in a very early case of Marbury versus Madison. But there's a lot left up to historic development as to how these different branches ought to relate to one another. And over the course of the 20th century in particular, that has meant the presidential power has grown dramatically. That's in part because of foreign policy issues. America's been more engaged abroad, and that tends to strengthen the hand of the president. But it's also true that Congress has passed a lot of broadly worded statutes, created an expansive bureaucracy, and that gives the president a lot of authority to make important decisions, or for the executive branch broadly to make important decisions. And the president has a big influence over the scope of the executive branch as a whole. And so you wind up developing a form of government that increasingly shifts power toward the executive branch. And often that means, in particular, authorizes the president to exercise a lot of policymaking discretion.
Yeah, I would just add to that, Ron. I mean, I'm a fan of the Federalist in its entirety, but 47, I think, ranks pretty high up there, where James Madison talks about the sort of the design of the Constitution really being intended to have the branches not just checking each other, but incentivized to push the envelopes of their own authority. The idea, I think the line is, ambition must be made to counteract ambition, where the notion was that only by all three branches really asserting themselves and pushing back against each other could you really have a healthy separation of powers. And what Keith describes is exactly right, which is that what we've seen throughout really most of the second half of the 20th century and the first quarter, or at least fifth of the 21st, is much less pushing from the legislature and the judiciary while the executive keeps going. Right? I mean, with the exception of Jimmy Carter, I don't think there's a modern president who has not seriously pushed the envelope when it comes to sort of interpreting either statutory authorities in ways that Congress might not have intended or their own constitutional power. And the result is that you have this sort of attrition of power to the president without formalization of it. And I think a really good example of that came during the Trump administration. Just to take, well, there are like lots of examples of that during the Trump administration. Just take one of many vacancies, right? Vacancies, an area where Congress has always had a heck of a lot of power, both formally and informally, to ensure that the president couldn't abuse the Senate confirmation process and just temporarily install, patrons or, just completely incompetent buffoons. And yet we saw some of that. Why? Because Senate Republicans would not stand up to President Trump, right? And there's a meme in political science I think is really powerful, that we increasingly have the separation of parties in Washington, not the separation of powers, that Congress will push back against the president when Congress is controlled by a different party, but not when it's controlled by the same party. And the result is just this increasing buildup of executive power, where we might be okay with it if we like the particular executive of the moment, but the long-term implications are all bad. So, to me, the biggest sort of disease in separation of powers today is that the sort of model of ambition counteracting ambition has given way to, as long as we're in charge, institutional relationships don't matter. And that's, that has, I think, the obvious and even less obvious negative ramifications.
Let's take the next logical step. Excuse me, but before we do, we just want to make a quick observation. Stephen, you said in Federalist 47, authored by James Madison, and then you went on to extrapolate after that. And I will note that we're talking about the same James Madison as the Madison in Marbury versus Madison. So we're talking about the same individual. So which
Ron, I think actually dovetails perfectly with the last point, which is James Madison, who wrote the Constitution, had fairly different views than James Madison, who was Thomas Jefferson's Secretary of State, who had fairly different views than James Madison, who was president. I mean, just look at Madison's views on the constitutionality of a national bank, right, change at least 3 times, depending upon what job he has.
And if we're piggybacking on Madison, I would just note that, right, Madison also says in the Federalist Papers he expects Congress to be what he characterizes as a legislative vortex that's going to absorb all powers to itself, which is very much what he thought he'd observed during the Confederation period, that state legislatures tended to take powers away from governors. The governors and judiciaries were very weak in the state systems, and he expected Congress would do the same thing. And you might think that was largely true through big chunks of the 19th century, where Congress was very aggressive in asserting its own powers against other branches. But in the 20th century, it really has changed. Congress just is no longer willing to assert itself in the same fashion that it once did. And really that people like Madison expected Congress would be the branch that we'd have to worry the most about, being too assertive in exercising its powers.
So you have both led me in a delightful fashion to my next question, and that's the question of executive orders. Under the aforesaid Article 2 of the Constitution, which vests executive powers in the president, it does not mention executive orders. Executive orders have been more evolutionary than enshrined within the Constitution itself. Although executive orders have been used from everybody from Washington to Truman to Nixon with the Pentagon Papers, let's talk a little bit about the evolution and the sort of reading between the lines of the Constitution to authorize executive power.
Sure. So executive orders are just a mechanism that presidents use to exercise their own authority, to give instructions to the rest of the executive branch about how to implement policy, and in particular, how to implement statutes. And so the theory behind executive orders is that they are not themselves acting in the form of law. They're not supplanting what Congress has done, but rather an effort to implement what it is Congress has done, or what the president has his own discretionary authority to do. In some ways, I think we can fetishize executive orders a little too much. We tend to do the same thing lately with signing statements as well, where we give a lot of attention to this particular formal document that some presidents sometimes issue. And really, this is just one tool that presidents use to try to control the bureaucracy, try to control the executive branch, try to give instruction from the White House to the rest of the executive branch about what it is they want to do. Presidents have a lot of different tools for trying to do that. They make use of lots of different tools to try to do that, and executive orders are one of them. Part of why, though, they've become so prominent and important in current presidential politics is precisely because there is so much discretion vested in the executive branch. There are lots of important choices to be made by executive branch officials. And the White House struggles to try to get control over the larger bureaucracy in order to try to give direction from the White House as to how that discretion ought to be authorized and used. And that gives a lot of space for presidents to be issuing executive orders, but also sets up a kind of struggle between the White House and the rest of the executive branch over how that policymaking authority is actually going to be used in practice that Congress, in many cases, has handed over.
I mean, to put the matter a little bit more less elegantly than Keith put it, right? I mean, there are people on social media who are just sitting there counting executive orders and saying, well, whoever issues the most is the worst president. And that's just not how this works. I mean, you know, most executive orders, or at least many executive orders, are entirely anodyne in the sense that they are dealing with executive branch bureaucracy, maybe not the exact way we would, but in ways that everyone understands are up to the president. I think, Ron, what has become controversial about executive orders is presidents relying upon them after they were unable to get policy initiatives through the legislature. And this is a small subset of executive orders, where the executive order is effectively trying to legislate through the back door based upon creative interpretations of what statutes there are on the books and or novel interpretations of the president's Article 2 authorities. And, you know, I think to sort of tie this back to the last question, two things have facilitated the rise of that kind of executive order. One, Congress not punishing the executive for doing that. For example, by withholding funding from the executive branch, which Congress has the power. The power of the purse is at least meant to be, back to Madison, right? One of the Congress's strongest levers against the executive, seldom pulled. But two, and this is getting into sort of more nerdy legal context, but you know, the Supreme Court has made it so difficult to sue the executive branch over the last 35, 40 years that it is a lot more likely that a controversial executive order that, you know, is a response to not getting accepted through Congress will be effectively immune from judicial review today than it was 40 years ago, which of course means there's no disincentive for the president to do this thing and say, look, base, I've done this big visual thing, whether it's Trump and immigration or Biden and, you know, LGBT discrimination in the workplace, right? I mean, pick your president, pick your policy. And the ability of parties to challenge that has become greatly circumscribed in the courts. Whereas I think in a healthier separation of power system, right, there would be pretty powerful disincentives for presidents to push the envelope too far. So, you know, I don't think executive orders themselves are the problem. I mean, as long as we have a take care clause of Article 2 that gives the president at least some discretion in how the laws are enforced, executive orders are inevitable. I think the problem is using them to do what Congress refused and then not having any meaningful accountability if you're going further than the law really reasonably allows.
Let's switch course entirely here and go on to a topic that's completely, to use your term, Steve, anodyne. Let's talk about the Second Amendment. What does it say? What was it intended to say?
So the Second Amendment says that people have the right to bear arms, and it has a preamble that specifies that the reason why you want the people to have the right to bear arms is because there's an argument that a well-regulated militia was important to maintaining a free society. There's lots of debate about what exactly the implications of that are, right? How big is the scope to bear arms? How important is that preamble that attaches the right to bear arms to the specific justification of a need to have a militia? Through much of American history, this is thought of what gets characterized as being a collective right. That is, that the right to bear arms is primarily about militias and the ability of states to form militias and arm their militias. Our current debate is the extent to which this is instead understood to be an individual right. The individual citizens have a right to bear weaponry, own weaponry, carry weaponry to some degree. And what are the limitations on that kind of right? So the court's current interpretation is this is an individual right, and there's some contestation still as to what the scope of the right is. And so the court has said it's an individual right. It's a right that incorporates part of its justification as being one of allowing people to engage in self-defense. At the very core, that includes self-defense in their homes. And part of the marginal debates now coming out of those doctrines is a question to what degree can likewise people have a right to carry weapons outside the home for self-defense purposes elsewhere. And so, the state constitutions include similar kinds of provisions in many cases. The Anti-Federalists advocated for something like the Second Amendment. Many of the state ratification conventions after the federal constitution was drafted included proposals for something like this language to be incorporated in the Constitution. It was a source of a great deal of concern at the time. But there's a lot of variation as to what exactly people were worried about, what exactly people were talking about, that then creates confusion as we're trying to interpret, okay, well, what is the nature of this right that wound up getting embedded into the text of the Constitution?
Stephen, before I have you comment on this, I'm going to marry two concepts. Something that I want to see if we can find time to talk about today is originalism. But I'm going to ask you to answer the Second Amendment question in the context of originalism. It seems to me that largely conservatives are in favor of free ownership of firearms. And yet, if you construe the preface into the Second Amendment as a well-armed militia being necessary to the public defense, the originalism argument would argue against that private ownership of firearms.
And indeed, I mean, this might be picking a little bit of a fight with Keith, but why not? It's we're halfway through, right? I think indeed it's telling that the best evidence of support for the sort of individual or private self-defense reading of the Second Amendment actually comes from the Civil War era, right, which the Supreme Court relies upon in 2010 when it says the Second Amendment applies to the states. Then from the founding era, when the Second Amendment is initially proposed and adopted. And Justice Scalia's majority opinion in the Heller case in 2008, which is what adopts this individual right view, I think does a fairly mediocre job of culling the relevant historical sources, and indeed has been criticized even by fairly conservative defenders of originalism for sort of fairly what we call law office history, right? Sort of amateur constitutional history. I think originalism is, in some respects, my response to the originalist question, Ron, does tell my response to the Second Amendment question, which is everything in moderation, right? So the Second Amendment debate to me is so much more about how much government regulation is reasonable than it is about sort of the terms that take place in public. I mean, there's a congresswoman from your part of the world who is on record as saying, of course, the Second Amendment's absolute. Anyone who says otherwise, is a tyrant. Well, Justice Scalia said otherwise in Heller, right? He was quite clear that there's lots of room for states and even the federal government to engage in reasonable regulation, especially outside the home. Federal courts have consistently upheld, even after Heller, assault weapons bans, right? So, I think it's one thing that's, even for those who are willing to buy the individual and private self-defense via the Second Amendment, and I'm sort of on the fence about that. That doesn't answer the second big question, which is, but to what end, right? How far out of the home? And indeed, the Supreme Court, as I think just agreed to take up a public carry case and really the first time since the Heller and McDonald cases, 2008, 2010. It's going to give us a lot of insight into that. I suspect they're going to go a lot further than I would. But to the originalism point, I don't think there is a serious constitutional scholar out there who would argue with a straight face that originalism is irrelevant, right? That we should never be remotely interested in what was intended for these words, in how they were understood at the time they were drafted. The question is sort of, one, is it the only thing we should care about? And two, if so, what do we do in cases in which the historical record, such as it is equivocal at best? And a really good example of this is the war powers, where, with the exception of literally a single law professor and former Bush administration official, the overwhelming scholarly consensus is that most modern conceptions of executive branch unilateral war power have no support in founding our understandings. The Supreme Court, with a lot of originalists, has hewed toward that view anyway, right? Because there are contexts where even originalists aren't necessarily committed to originalism. And so I think, the key again is like, originalism as an idea, I think, is not controversial. The notion that originalism is the only objective way to interpret the Constitution is what I chafe at.
Let's take another pivot here and talk about something that I think should not be necessarily controversial, but has become so in our modern context. And that's interpretation of the First Amendment's right to free speech. I think years ago, not that many years ago, people would have no real debate about it. But I want to talk about it particularly in the context of speech on college campuses and what some people might call cancel culture, and also in the context of the ex-president being barred from Facebook and Twitter. Can you talk about the First Amendment right to free speech in those contexts?
Sure. So First Amendment's often contested, and so we've gone through periods in which there is quite intense debate about how to understand the First Amendment and how broad the scope is. Part of the story of the 20th century is a gradual expansion of how we understand free speech rights playing out in courts. And part of what's interesting about the course of that 20th century debate is the extent to which conservatives, who at one point were quite supportive of restrictions on speech, have become much more libertarian about how to think about free speech. And we're seeing progressives start to make the shift in the other direction and become more supportive of greater restrictions. And I think it remains to be seen what that winds up looking like in the next 10 or 20 years down the road. So there is a substantial debate about, in college campuses particularly, about the scope of free speech. I think that debate is somewhat different from a legal perspective as to whether we're talking about state universities or private universities. If we're talking about state universities like the University of Texas, they're constrained by the First Amendment as applied through the 14th Amendment. And as a consequence, there are constitutional restrictions on what those campuses can do. If we're talking about a private university like Princeton University, on the other hand, they have a lot more flexibility about what kind of restrictions they can adopt. Most American universities have adopted very robust conceptions of free speech on campuses. Princeton has voluntarily adopted a very robust conception of free speech on campus, but they could choose to do something narrower, and some schools do have narrow restrictions, including a lot of religious institutions, for example, adopt lots of restrictions on faculty and students' speech. And there are lots of complications about how that plays out in particular contexts, which I'll bracket for the moment, just because it will get us into the weeds. And I say though, there's similar implications in thinking about the other context that you raised, which is the context of social media and internet companies and how they're restrictive of speech. They're situated like Princeton University. That is to say, they can adopt what kinds of regulations they want in terms of how restrictive they want to be. And we can easily imagine circumstances in which we would think that would make a lot of sense. So for example, if the Walt Disney Corporation decided to create a social media environment for children, we would expect it to be highly restrictive about the kind of speech it would tolerate within that environment, because that's the kind of context they want to create. But there's nothing intrinsically different about that example and Facebook and Twitter or any of these other organizations. They have to make choices about what kind of social media environment they want to create, what kind of business they want to operate, and then they have to adopt rules reflective of that. And part of what we're seeing now is this evolution, I think, for a lot of these social media companies about how they conceptualize their own mission, what they think is in their best interest from a business standpoint, and then how do you actually apply these principles to particular applications in practice. In part, they're discovering what it is lawyers and judges have been struggling with for decades, which is it's one thing to embrace the principles. It's another thing to figure out how do you actually apply them consistently in practice. It's often hard. And it's even harder when you're trying to do it at the kind of scale that institutions like Facebook and Twitter are doing, and on a global environment where we're not just talking about an American culture with American politics and American society, but you're trying to regulate these things across the entire world with very different contexts, in which case it becomes extraordinarily difficult to figure out how do you apply free speech principles in a consistent and equal fashion in that kind of context.
I'm sorry, Ron, I think you're muted.
I'm sorry.
I think you're muted again.
No, I'm not.
So sorry, you were saying.
All right, I don't know if you can hear me at this point.
Now I can.
Yes.
Okay. So I want to give you an opportunity to respond to this, but I want to be mindful of the time. And I want to save just 2 or 3 minutes before we go to Q&A about the Swiss Army knife of the 14th Amendment. How the Swiss Army, or I'm sorry, how the 14th Amendment has been applied to any and everything beyond what may have been its original intent. So respond, if you will, to the First Amendment question. Let's just save a minute or two for that.
Well, actually, I mean, I actually think I can tie them together because I think this dovetails. So what Keith is getting around is and sort of, I mean, going into more detail than I could in that short time, is something called the State Action Doctrine, which is actually something that the Supreme Court first articulated in the context of the 14th Amendment. And the idea is that with the exception of the prohibition of slavery, there's literally nothing in the Constitution that regulates private conduct. And that's very much by design, right? That it's, you know, it is a very sort of libertarian streak, I think, in the Constitution. And at various points in our history where there have been opportunities for the Supreme Court to revisit that understanding, the court has quite consciously refused to do so, including first and most importantly in 1883, in the context of the Civil Rights Act of 1875, and then during the Civil Rights era, where the court had multiple opportunities to do it again. And, you know, it is the State Action Doctrine, it is so important to understanding how our legal system works today. And there are folks who just sort of blithely say, well, Twitter and Facebook are effectively state actors, or, you know, they're public utilities. And, you know, once you cross that bridge, there are a whole lot of other things that would follow that some of the people clamoring to apply the First Amendment to Facebook and Twitter might not be in a hurry to have apply. Right? That, you know, the notion that Keith at a private university is not bound by the Constitution is something that allows Princeton to do lots of things that my employer cannot. Right? And so, you know, I think as is so often the case these days, the rhetoric so grossly misses the nuance of the conversation, where, you know, whether we're comfortable with the amount of power these companies have in the abstract is a separate question from whether we should abandon the State Action Doctrine. And yet, you know, people like the junior senator from my state, who know better, who went to Harvard Law School, who was the Solicitor General of Texas, you know, stir the pot by saying, no, we have to get rid of the, you know, we have to do this. And so, Ron, to your question about the 14th Amendment, right? The 14th Amendment is I think, without question, the most important single provision in the Constitution, except that it's not one provision, it's 11, right? And I guess I'm going to die on the hill that the 14th Amendment actually has been interpreted not to do everything it was meant to do, since it was ratified in 1868. That the Supreme Court at various points has underinterpreted its terms, partly because of this exact concern that over-interpreting the 14th Amendment would allow for far too much federal either regulation by Congress, which has the power to enforce the 14th Amendment in Section 5, or by the courts in enforcing Section 1 of the 14th Amendment over private conduct. Right? That one of the great debates about the scope of the 14th Amendment is, does it only apply to the states, or does it actually apply to private parties as well? And so, you know, color me as someone who thinks that if you actually put it in the broader context of history, the 14th Amendment today is understood to do less than its drafters intended. And that's especially true with regard to what the drafters called the privileges or immunities of citizenship, which the Supreme Court effectively sort of vitiated in 1873 in a case called the Slaughterhouse Cases. Right, where, you know, I think the reality is that the current court in particular reads the 14th Amendment to protect far fewer constitutional rights than it was intended to protect.
Keith, let me give you last word on this sort of prepared section, and then let's invite Claire back to do a little bit of question and answer.
Yeah, well, I think that the question of the 14th Amendment is a great place to wind up at this level. The 14th Amendment is extraordinarily important, as Steve notes. It's very expansive in the kinds of rights it grants, and in part because it's so potentially expansive, It's always created difficulties for the court to figure out where are the limits here exactly, and to what degree does it completely upend the nature of the American federal system by shifting a lot of power over an extraordinary amount of private activity to Congress and maybe to the federal courts more broadly. The Privileged Immunities Clause is clearly underinterpreted by the court, has been throughout history. It's clear that those who wrote the 14th Amendment and meant for that clause to be doing a lot more work and protecting a lot more rights. Part of the challenge of thinking about the 14th Amendment is not only how to integrate it into the continuing existence of the larger American federal system, but also part of the challenge is, as well, sort of is a challenge that was rooted in the very origins of the 14th Amendment itself. That is, its strongest advocates wanted it to be extraordinarily broad, but it's not clear they had the votes to be able to do that. And so you had a lot more people who were more on the fence, who ultimately were crucial to being able to pass the 14th Amendment, who wanted something much more modest. And so you get this sort of compromise, not only in the language of the 14th Amendment, but also in the understanding of the 14th Amendment as it's being expressed and debated at the time. And that gets carried into the court system pretty quickly. So we wind up continuing to debate the same debates they were having during Reconstruction itself.
Okay.
Gentlemen, thank you. Let's open this back up to question and answer.
Thank you very much. I would like to stay here on the 14th Amendment and just ask if one of you, perhaps Professor Whittington, would kind of sum up what exactly is in the 14th Amendment for those of us who may not know.
Yeah, no, totally fair. I will make Steve detail the many provisions he wanted to note about the 14th Amendment. So there are three big ones, though, that continue to have a great deal of relevance to American constitutional law. The Equal Protection Clause, which we're sort of familiar with that kind of language, which is fundamentally about treating that the states have an obligation to treat citizens equally. And of course, we debate what that means in practice. The Due Process Clause, which requires that the states not deprive people of life, liberty, or property without due process of laws. This has been the vehicle by which courts have understood the states to be bound by all kinds of rights relative to individuals and restrict what kind of state authority they have. And then the Privileges and Immunities Clause of citizens, which is the provision that the court has not paid much attention to, but was clearly a vehicle by which those who drafted the 14th Amendment thought that they were going to protect a lot of federal constitutional rights for individuals against their state governments. I should just note that, broadly speaking, the 14th Amendment is one of the Reconstruction Amendments adopted after the Civil War. It was designed precisely in order to provide federal constitutional protections for individuals against their state governments, which is something that the Bill of Rights was not really designed to do with the federal Constitution. It's mostly not what the federal Constitution is concerned about. It's mostly about restricting the federal government. It has some restrictions against the states, but not a lot. Part of what's significant about the Reconstruction Amendments is it generates a lot of new federal constitutional limitations on what states can do. And the 14th Amendment, the most important of those from sort of a day-to-day practice perspective.
I mean, to put it, Claire, to put it sort of a little more bluntly, right? The reason why a Colorado state court is required to provide criminal defendants with access to counsel. I mean, there may also be a provision in the Colorado Constitution, but the easy short answer in states that don't have such provisions is because of the 14th Amendment. Is because the Supreme Court first says the 6th Amendment requires this, and then says, and because of the 14th Amendment, states must do this too. Multiply that by about 1,000, and you start to get you get to why Section 1 of the 14th Amendment is important. So Keith mentioned the three key rights in Section 1. There's also the Citizenship Clause of the 14th Amendment, which guarantees citizenship to anyone born in the United States, which of course was the expressly overruling Chief Justice Roger Taney's infamous opinion in the Dred Scott case. There's Section 2 of the 14th Amendment, which gets rid of the 3/5 compromise and requires apportionment based on equal citizenship. There's Section 3, about which we've heard quite a lot this year, which purports to disqualify from serving in Congress individuals who have been involved in insurrection against the authority of the United States. It's lost to history, but Section 4 prevents the questioning of the public debt of the United States. and also bans the federal government from assuming the southern states' debts from the Civil War. Like this actually had enormous financial ramifications for the first 40 or 50 years after the Civil War. And then there's Section 5, which is Congress's power to enforce all of that. So, you know, I think the sort of the one sentence version is that the 14th Amendment fundamentally rewrites the relationship between the federal government and the states, but all with an eye toward providing us with more ability to hold our states accountable when state laws are inadequate to that end.
Let me make one quick comment here and then Claire go on. The 3/5 compromise that Steve referred to, which was repealed by the 14th Amendment, was where African Americans were considered 3/5 of a person.
So our first question comes from John, and it circles back to the issue of the Electoral College. As he states, both of you seem to accept without question that the Electoral College is a problem. It, like the Senate, was designed to protect the interests of the states with smaller populations. Colorado is 21st in population. Why would you want to yield power to more populous states, primarily California and New York? And to that, I would only add, is there a historical link between the Electoral College and the institution of slavery?
I mean, the short answer to your last question, Claire, is yes. Right, that I mean, Rohn mentioned the 3/5 compromise. There are a number of provisions in the Constitution as it was originally drafted that were, if not in whole, at least in part, compromises and concessions to Southern states in general and slave states in particular. The Electoral College was part of that story, although that one's a little more complicated than the 3/5 compromise, which was actually like straight that story. You know, I think there is a meaningful difference between the extent to which the Senate is meant to protect the rights of small states in our system and the extent to which the Electoral College is. Because the Senate, right, the two provisions of the Constitution that cannot be amended are the equal suffrage of the Senate, the notion that every state gets the same number of senators, and the ban on the inability of Congress to ban the slave trade before 1808, which of course is now moribund and defunct. Right, Claire, that was it. And so the Electoral College, I think, incorporated the sort of power of small states through the Senate. But of course, as I said at the top, right, that was dependent upon the size of the House. Right, that there's no reason why, if, for example, the first proposed amendment in the Bill of Rights had been adopted, we would still think of the Electoral College today as a small state protecting feature. It's just an accident of history, right, as opposed to the Senate, which was quite consciously designed to do that.
I should say I'm much more sympathetic to the Senate as well as the Electoral College than as a consequence in terms of political principle of constitutional design more generally than most scholars are. And so I actually have a lot of sympathy with aspects of the Electoral College, and I have a lot of sympathy with the kind of practical problems the founders were struggling with that led them to design the Electoral College. But nonetheless, that should not blind us to the fact the Electoral College has all kinds of weird features to it, that if we were doing it again today, even if we were sympathetic to those principles, we wouldn't embrace all those features, right? And so most of what we tend to focus on and talk about with the Electoral College is the allocation of electoral votes, which just mirrors the structure of Congress more generally. But notably, the Electoral College has other important features to it that I think are even more problematic than that one in terms of how they work. So, for example, they authorize state legislatures to determine how the presidential electors are selected, which in part reflected the fact that the founding era wasn't clear how they were going to go about doing that. In practice, we very quickly moved to a system in which the people themselves voted for the presidential electors, but it remains the case state legislatures have the authority to override that, and that creates all kinds of potential mischief. We actually have human beings who serve as presidential electors, and as a consequence, we create a faithless elector problem that in practice has not been a severe problem, but could be a terrible problem under the right kind of circumstances, right? So if we were designing this kind of system from scratch, even if you liked the basic allocation of electoral votes, I don't think you would want to retain those features of the Electoral College in any kind of modern constitutional design if you had your choice.
Professor Vladak, today, Texas Governor Abbott signed a law banning abortions once a fetal heartbeat is detected. But this law prohibits public officials from enforcing the law and leaves it up to private citizens to sue the violators. Your colleague, Elizabeth Sepper, argues you can't cut off the US Constitution by framing what's really a state law as a private matter between citizens. Do you agree with Professor Sepper?
I do. I mean, the Texas law, as you say, Claire, has two features, both of which I think are sort of separately but equally nefarious. So the first is the fetal heartbeat rule, which basically means that as of, I think, September 1st is the effective date of this law here in Texas, abortions will be unavailable once a woman reaches 6 weeks of pregnancy. Just to be clear, that's not 6 weeks from when the woman finds out she's pregnant. It's 6 weeks from her last period, which, most women don't know they're pregnant at that point. So it would effectively ban abortions throughout the state. That, as long as Roe and Casey are still on the books, and maybe they're not much longer on the books, given what the Supreme Court did on Monday, agreeing to take up a case about a Mississippi law that bans abortions after 15 weeks. But so long as those are still good law, that ban's unconstitutional, and that's not even a close question. The weird thing Texas is trying to do is to manipulate something called the Standing Doctrine, where the idea is to empower private parties, any private party, any person in Texas, to sue someone they believe is violating the prohibition on abortions after 6 weeks. And, without even getting into how messed up that is as a policy matter, in the federal courts, that's a non-starter, because there's something called the Standing Doctrine. The Supreme Court has read into Article 3 of the Constitution, which the Supreme Court says prohibits, right, citizen suits, just anyone suing because they're mad about something, right, where you have to show that you, in fact, were personally injured, that your injury was caused by the person you're suing, and that the court can redress the injury. So, I think this is sort of yet another fairly cynical attempt by my state to, both sort of push the Supreme Court to scale back Roe and Casey, and to actually make it, even if that part gets struck down, in the interim, to make it really easy for people to be scared off from vindicating their constitutional rights, because they're worried about a lawsuit. They're worried that this provision subjects them to all kinds of civil suits. No one can deny that the question of abortion gets everyone's dander up, and I completely understand that. But there's a right way and a wrong way to raise these kinds of issues, and I have no problem saying that Texas is doing it absolutely the wrong way, and it's not the first time.
So my next question is for Professor Whittington. It's a busy day in Texas. When we kicked off our program, Quinton Jones was scheduled to be executed. I don't have confirmation if that execution has taken place, but my question to you is, how do you square execution with the Eighth Amendment's prohibition against cruel and unusual punishment?
Yeah, well, it's obviously a question the court has struggled with over time as well. There's sort of two kinds of complications, I think, that are particularly associated with that question. I mean, one is the particular methods and practices by which we impose the death penalty and then implement the death penalty, and whether or not those run afoul of the Eighth Amendment's cruel and unusual punishment clause. And some of the justices have certainly been sympathetic to that view. The particular way in which we try to conduct capital punishment in the United States has problems. And then there's a stronger view, which is that any form of the death penalty, no matter what the details are of the implementation, that it runs afoul of the Eighth Amendment. That's, I think, a harder lift, in part because the Constitution explicitly anticipates the existence of a death penalty. And so many think that's implausible then that the Eighth Amendment can necessarily rule out the death penalty when the constitutional text seems to anticipate the existence of a death penalty. But then again, it turns on your understanding of the Eighth Amendment and how we should think about the language. Some view it as an evolving principle over time, such that even if the death penalty was constitutionally valid in 1787, for example, it might become constitutionally invalid over time if we think that the substantive meaning of the principle embedded in the Eighth Amendment has changed over time. So there are a variety of challenges here about thinking about how to reconcile the Eighth Amendment with the death penalty. The court continues to struggle with those, although I don't think that anytime soon there's going to be a firm majority on the court that's going to be tempted to strike down the death penalty wholesale, and it's going to be pretty tolerant of how the death penalty gets implemented in lots of circumstances.
My next question comes from Bob Rush, and Professor Vladak, we'll start with you. He's asking about the Citizens United case that considered corporations as people and had a significant impact on campaign finance. I'd like you to weigh in on that decision.
Well, this actually goes back to, Keith mentioned a few minutes ago when we were talking about Ron's First Amendment question, how there was a period of time where sort of the notion that corporations should be free to make their own choices was very much the doctrine of conservatives. And I'm old enough to remember when that was. It was, 5, 6, 7, 8 years ago. The Citizens United decision is a 2010 Supreme Court decision, and it's about a series of fairly significant campaign finance restrictions on contribution limits directed toward corporations. And the idea was to try to keep so-called soft money out of elections to the maximum extent possible. And in striking down these restrictions, which I should say were this remarkable bipartisan thing. I mean, McCain, Feingold, and McConnell, right? Mitch McConnell had his name on a bipartisan piece of legislation. Like, when was the last time that happened? Right, but that, the McCain-Feingold legislation was such a bipartisan thing. Court says, no, you can't do it, right? Because corporations have at least limited First Amendment rights to engage in political activity. And political activity in this context is, donating money to political campaigns. Citizens United is often maligned as, sort of like corporations are people too. That hasn't actually been where we've gone. Like there's no corporate Fourth Amendment rights and corporate Second Amendment rights and Fifth Amendment rights. The other piece of it is, I think as recent Supreme Court decisions go, it's not quite as obviously pro one party or the other. There's a ton of dark money on both sides. I think it's just generally bad for transparency in our electoral process, and that in different parts of the country that will tend to benefit one party more than the other, albeit not always the same one. I guess when I think of the sort of the things I would fix if I was in charge of the world, Citizens United is pretty far down the list, right? That it seems to me that, the sort of keeping corporate money out of politics is an important idea, but there are so many other things I would attack first. And part of that is trying to have more transparency in politics. So, for example, can these corporations actually funnel money through secret, sort of no-name LLCs and then not be required to disclose where the money comes from, right? That's part of the question, right? Should there be disclosure requirements about donors in other contexts? So I guess, Claire, Citizens United, I think, is a boogeyman that I think is problematic, but is sort of pales in comparison to the bigger, I think, problems we have with the current structure of our political system, and which the extent to which the Supreme Court has insulated that structure from constitutional challenge. And just really quickly, I think a much, much more grievous sin is the court's decision 2 years ago in a case called Rucho versus Common Cause, where the court says partisan gerrymandering can never be challenged in court. Right, which is a much bigger deal to me than saying, hey, you can have lots of corporate money in elections, because now it means like a state like North Carolina, right, can say, hey, we're going to draw our districts, we're a 54-46 state, but we're going to draw our districts to have a 19-to-1 House delegation. Well, that has enormous downstream effects on what our political system looks like, because in a world in which there's no requirement that you draw seats to look like your population, every seat becomes a safe seat. And primary elections become so much more important than general elections. And so it becomes much more important to have candidates who can win primary elections, which means candidates who are at the extreme of their party, than candidates who can win general elections because the seats are manipulated, right, in such a powerful way. So I would so much rather start there in curing the ills of our political system than in sort of getting money out of politics, because money is a sort of a symptom of the problem. It's not the problem itself.
I would just footnote that to note that Mitch McConnell was a critic of McCain, Feingold, and led lawsuits against big components of the law, in part because McConnell thought that would wind up empowering outside groups and disempowering political parties, and turns out he was mostly right about that.
Touche.
We are out of time, and I said I would give you all each an opportunity for some final words. We just came through a pretty challenging year in many different ways, and certainly our democracy was challenged, I think. And I'm wondering if you could comment on that in context of the Constitution. And we'll start with Professor Vladak.
I mean, we saved the elephant in the room for the last 2 minutes. You know, I think the sort of the two big takeaways I have from the last year, and especially the last 6 months, when it comes to the Constitution, is one, the Constitution is actually a fairly what's what I'm looking for, resilient document, in the sense that it actually can handle a fair amount of stress. But two, it's not nearly as sort of impermeable and sort of the Constitution is not what's going to save us. And so when I think about sort of where we are going as a political culture, it seems to me that, you know, we should all try to get out of the habit of caricaturing the other side, of, you know, sort of treating everything as if there's no nuance when, you know, there's a ton of nuance. And we should all sort of not just assume that things are going to work because they always have, right? And so to me, you know, thinking about sort of the future of the Constitution of this country starts and ends with a polity that is motivated, and that is, you know, turning out for elections, that is actively engaged, that is not just accepting what is being told by whichever, you know, slice of the media it participates in. Right, that sort of skepticism is what we need. You know, healthy, informed, educated skepticism is what's going to get us through this, not just sort of faith that our system is, you know, as Churchill said of democracy, right, the worst form of government except for all the others.
Yeah, let me echo some of that as well. I think I would also emphasize, I think the Constitution is extraordinarily resilient. The constitutional system as a whole is quite resilient, but I think one thing that the last few years has emphasized to everyone, I hope, is that constitutional rules are only part of the constitutional system. Constitutional practices and norms and values are also extraordinarily important. And that means not only do we need to faithfully adhere to constitutional rules in order to make them work right, but we also need political actors, both ordinary citizens as well as elected government officials, to actually care about how the constitutional system operates and try in good faith to help sustain it and preserve it. And that means not always trying to figure out how do we cut the corners on the constitutional system, how do we adhere to the letter of the law while trying to work around the spirit of those constitutional rules. We need people to be faithful to maintaining a healthy constitutional order as a whole. Otherwise, the constitutional rules by themselves certainly will not preserve the republic in any fashion that we care about. And I think especially in a polarized political environment, there's always going to be temptations to find ways of cutting constitutional corners. And ultimately, I think that's going to be very corrosive to our ability to have a resilient constitutional system. So we need to pay attention not only to the rules, but also the kinds of shared practices that help underwrite those rules and help flesh out those rules so we have a functioning democracy.
Ron, I'd like to give you the last word.
Well, I'm not sure I deserve the last word when I'm sharing a forum with these two gentlemen, but let me just pick up on something that Steve said, and it actually led into the thoughts that I have. He used the words resilient and nuanced, and I would use a further word about the Constitution, and that is expansive in its brevity. And even though that seems somewhat oxymoronic, I think the great wisdom of the Constitution is that not everything was said, that what was said in the fewest words possible to allow for evolution, to allow for future generations to fill in their own blanks. And I think in terms of the political context, our challenge and the challenge of the next generation is to fill in those blanks with wisdom and in a context that's both appropriate with the original spirit of the time when the Constitution was adopted, but also in modern times.
Thank you all so much. This has been such a powerful start to our summer season. Thank you for your time and for your expertise. Ron, great job. Thank you all. And I hope you'll join us for our program on June 3rd when we take a look at rare earth elements. Thank you, everyone. Good night.